Welcome to the Extra Mile podcast for bar exam takers. There are no traffic jams along the extra mile when you're studying for your bar exam. And now your hosts, Jackson Mummy and Megan Saya from Celebration Bar Review.
Hey everybody, welcome. Today is, it's Wednesday, February 16th. Is there anything going on this week, Megan?
Yeah, not this week, but in just a few days, the bar exam is happening. Hooray.
Megan's here with me as always, and June is here as well. Hi, June. How are you? Yeah, this is a big week, right? We are in that final 6-day countdown to the bar exam. We still have people taking the exam in February. I know that a lot of people have decided for various and good reasons to postpone, but we still have lots of people taking the exam in February. And today we have a bunch of questions. We asked our students this week, what's your biggest remaining challenge? And we're going to try and address as many of those questions as we can today. We've got a lot of them to get through. They're great questions, and I'm excited to talk about that. And we'll answer your study questions and the last minute things that come up. Megan, I'm sorry I took over there, but I'll give it back to you, and why don't you steer us around here and see what we've got to talk about.
Yeah, no problem. So the only big news that's happening in the world of the bar exam right now is that Florida has changed some of their rules for who they will allow to sit for the exam in Florida. Jackson, if you want to talk a little bit about what's happening with foreign trained attorneys in Florida.
Yeah, this is an interesting change. For many years, unless you went to law school in Puerto Rico, all foreign attorneys were prohibited from sitting for the Florida exam. That was an absolute. And then a couple of years ago, they started opening that up and said if you had 7 years of experience, which is a lot of years of practice as a foreign attorney, you could then come and petition, and perhaps you could have the opportunity to sit for the exam, but it was not a clear path to taking the exam. In this last decision of the Florida Supreme Court, at the recommendation of the Florida Bar, there's now a 5-year practice requirement for foreign trained attorneys, and then you will be allowed to sit for the exam. The only thing I want to point out here is that it is not a waiver in. So if you've been practicing law in Brazil or in South America or anywhere in the UK, it now means that just like in California or New York or Texas, you have a route to sitting for the bar exam, although it's a longer route. If I remember correctly, in California, I think it's only like a year that you had to be as a foreign trained attorney before you could sit for the exam. So in any event, Florida is now making that available. And I expect we'll see, because Florida is obviously a state that's got a lot of immigration going on, I think we'll see more foreign attorneys taking the exam. So we have worked with some foreign attorneys who have passed the exam here in Florida, but they had to go through a really long process just to sit for the exam. It's a good move. I think it might be the leading edge. Megan, you and I have talked about what's going to happen in 2026 when the bar exam starts to switch and California and Florida and Georgia and some other states have to make some decisions. So I think they're starting to position themselves a little bit in anticipation of that. So we'll see what happens.
Yeah, and I do want to point out that there's different rules for if you have your LLM. So that's for the 5 years is for people who are foreign trained and do not have an LLM from a law school, in accredited law school in the US. I believe it's 2 years of practice in the US if you do have an LLM. So
yeah, if you get an LLM, that certainly shortens the process, and it's a good thing to do.
Now let's turn to some of our questions. Moving to our newest MBE, let's talk about how we use this new test, because a lot of questions about that. So first off the bat, this is really important. I'm glad this person asked it. I hope that we were able to answer it quickly enough for them. Someone said they came across the MBE 2021 practice exam on the NCBE's website. It's for sale there. And they were saying, oh, should I go ahead and buy this? No, it's the same thing. You get it from us for free. It's part of your course package. I guess I should say it's not any additional, like you have already paid for it. And so please do not buy a copy of any MBE questions. You have every licensed MBE question is already included in your course. So do not waste your money by buying licensed MBE questions from the NCBE or from anybody else, because you're just double paying. So just as an FYI, you already have everything that you need. So I just don't want you to waste your money. Then the second question is, how should I use the 2021 MBE practice exam? Is it predictive? Is this the score I'm going to get? Is there a scale on it? How do I use this as I'm heading into the exam?
I suppose you want me to answer that, right?
Yeah, I can if you want me to.
No, I'm going to take a shot first. We don't know anything about the exam. No one's ever taken it before. There's absolutely no data points until you guys start taking it, which some of you are. If you take it online, we see those scores, which is very helpful to us. So for those of you that are taking it through the TestMoz application, that's helpful to us. But we know a lot of you are taking it offline. You're doing what that student said, they're downloading and taking it in paper and pencil. And I understand why you would do that. The problem is we don't know with this test what it means. We don't know if it's a good test or a bad test. And there is no scaling because it's not a real MBE in the sense that this was not a test given on a certain date and they just made it available. That's what we have with the February and July of 91 and the July 98. They were actual MBEs the way they were actually given out. Remember that the test today, even though there's 200 questions, only 175 count. And in this practice test, there are 200 questions and they would all theoretically count. The value of the 2021 test, in my mind, is that it includes federal civil procedure. This was the first mixed topic exam released by the examiners that has all 7 MBE subjects in it. Up until now, they've only been 6. So I think there's a real value there. The benchmark that I'm using to get a feeling is out of those 200 questions, I'd like to see you get 120 correct. That's what I'm looking at. But then I'm going a step further. When you report to us your score, your raw score, and that's the only score you'll have for this test, I am then going back and looking at your score on the February 91 and the OPEs to see if there's any kind of correlative effect. In other words, if you got 120 raw on the February 91 test and you got 120 raw on this test, that's good news. But if you got 120 raw on the February test and you got 100 on this one, well, I don't know, maybe is this that much harder? And that's what we're trying to figure out. Right now, we've had a couple dozen people go through it, that's all. So that's not enough data points to be at even close to significant for us. So I don't even want to tell you what it looks like. I'm looking at it, but it's really to help me and to help Megan. It is not, we can't tell you anything about it, just use it as practice. So you want to pick up from there?
I think the only thing I would add is for anyone who's comfortable after they receive their score report, pass or fail for the actual exam, if you want to share with us what you got on the MBE, because that will actually, it's not really helpful for us to compare how Susie did versus Joe, because maybe Joe is not really as prepared as Susie is. And so we would expect him to have a much lower score. But what's helpful for us to see is how did Joe do on the 2021 MBE practice? And then how did Joe do a week or two later on the real test? How did Susie do on the practice? How did Susie do a week or two later? So that would be very helpful if people are willing to do that, pass or fail, to let us know, or if you find out if some passing jurisdictions don't tell you your MBE score, but if you could tell us what your score was so then we can see how predictive this test is for future students. So it won't help you, unfortunately, but it would be very helpful for future students.
I will say this, I think everybody should take this test. I think it's good practice, and I would encourage every student taking the February exam to take this test. Don't take what we're saying about its lack of predictability as being, oh, it's not worth doing. It is very much worth doing. The questions seem to be challenging, and I think it's great practice. And as I said, it's an opportunity to do mixed practice. Now, if you've done all of that and you've done the 2021, remember that in the course, we have an online test bank of 800 questions that are questions drawn from all 7 subjects, and they're completely randomized. And if you're just looking to do 10 questions here, or 15 or 20 or 25, go into that test bank and just do them. It is not going to give you a score or a result unless you did all 800. And for goodness sake, don't do all 800 right now. But it's a great way to just get some practice as you're working through. And it's drawn from all of our questions. So there might be some you've seen before, but there might be some you just never got to in the course. So that's a nice tool to use. But before you get to that randomized group, make sure you get through the 2021 exam. And the last thing I'll say about this is if you're running out of time and you're saying, as we're getting questions, should I do MBE 2 or MBE 3 or the 2021? do the 2021. That's far more valuable, I think, at this point than doing MBE 2 or 3, because they are fundamentally flawed tests. That's why the NCBE gave them, they sold them to us to use. And I've written about that extensively, but just a reminder, should be the OPE that's got a couple hundred questions, February 91 test, 2021 test.
Yeah, great. Any tips on navigating an essay when you read a question and aren't really sure what the question is getting at?
Okay, so this is a great question. And I thought about it, and I went back and looked at all of the essays across every jurisdiction in July of 2021. So that was fun. And but what I saw, and this was really interesting to me, for the first time that I can actually recall, every essay in every jurisdiction had multi-part directed calls of the question. In other words, there was nothing that said discuss all issues or what are all the, there's nothing that was open-ended. It was all very direct. I think the examiners are transitioning to a more standardized kind of essay question in which they can say, we want to see this and this. And as a result, that's a huge advantage to a student like this who's saying, what do I do? I think that what you start with is you paraphrase the call of the question and get it up on your answer. And then you set up in your mind FLA and you ask yourself, what would the dispute be around this call of the question? And what would the parties want to achieve? Just play with it in your brain a little bit. Reset the facts, 1 or 2 sentences, go to your second paragraph, come up with what you think the arguments of both parties are, and then make up the law. If you have no idea, make up the law that you think supports each party's argument, so that in effect, you're creating a hedge or a boundary on both sides. And then in the third paragraph, pick one of those and explain your reasoning. Now, if you had to do that across every topic of every essay, you'd be in big trouble, no doubt. But when I look at this, most of the exams had on average 4 calls of the question, okay? So depending on what jurisdiction you're in, you had 3 essays, or you had 5 essays, or you had 4 essays, or you had 6. That's, everybody's different. But you're gonna know most of the law most of the time. So really when you do the math, even if you're in, let's say, the UBE, 6 essays, 4 topics, it's 24 topics that you might be tested on. There might be 2 or 3 that you're like, I don't know, but that's not very much. And you can use that hedging technique. And then on the rest of them, you're fine. So I think sometimes what happens, and I want to get your take on this, Megan, I think sometimes people focus on the little narrow part of the problem of how they're going to do. Those 2 or 3 things are not going to be the big problems. Most of what you do is going to be very easy and straightforward for you. Does that make sense?
Yeah, I think it does. And I don't know if this is a February student or July. I hope it's a July. If it is, I would say if you struggle with looking at a question and just not being sure what they're asking you to write about, I think you need to do personal writing workshop with me, or you need to do coaching with Jackson or myself. And it's not a failure. It's just acknowledging the reality of noticing and being able to figure out what you're being asked to do is crucial. It's maybe the most important skill on the bar exam, because if you know all the law in the world, but you don't recognize when you're supposed to actually employ it and how to actually stay on topic and give them what they're looking for, as opposed to scattershot, like I threw every law that I remember in constitutional law at this essay, you're just not going to be successful. So I would definitely say you should have some coaching, personal writing workshop. We talk a lot about this concept, how to do this. It's not something that we can answer in 2 minutes on the webinar very fully, although that was a really good explanation, Jackson. But I just would love to encourage this person. Let's really dig into how to do this, as opposed to there's not a one cool trick that you can do to like never have this problem again. But it's definitely, you can learn. It's a skill you can learn. All right. Okay, next. All right, this is a question about the MBEs. It's very long, so I'm going to see if I can make it a little shorter. Okay, this is about the format of MBE questions and how they don't give you anymore those 4 different case scenarios. Remember, Jackson, where it's like, be like a Roman numeral 1, 2, 3, and it's 1 and 2, but not 3, or 3 only, or things like that. So this person said, if the bar examiners are no longer asking questions in that format, should I skip those questions completely, or should I
Yeah.
still study those
Yeah.
anyway.
So the bar examiners are not giving questions in that format because they were horrific and no one liked them and they were just impossible. I would go ahead and do them because I think they're good learning exercises. I wouldn't get too worried about how you're doing with them. Does that mean it might lower your overall score a little bit? Yeah, but we expect that. So it's built in. I think if you're using selective intuition, that's a great opportunity to say, what's my gut tell me? I think if you go down the rabbit hole and try and figure that out, you're going to get really twisted. So remember, it's still a 90-second answer no matter what, but you won't see it on the bar exam. It's really there just to teach you some principles.
Yeah. Yeah. I think really at the end of the day, you should do it because you want to learn the law that question is asking about, or reinforce the law, or get a better understanding of it, or a different understanding. So I don't think there's any value in skipping it. It would take you longer to go through. Like this person had named the numbers on the MBE that took you longer than it would to actually just do those questions. It took you longer to go through and find them. Yeah, just go ahead and do them. Which I think brings up another thing that we tend to see at the end when we get close, which is people making up tasks to avoid doing the thing that they need to do. We see this when people start their studies, Jackson, and we see it when they start to end their studies. We see this task avoidance of, maybe if I print everything out myself before I can start studying, or getting to this point and saying, I'm just going to review and go through and see which questions do I really need to do and which ones do I not. Just do them. Just go ahead and do them, and don't create tasks for yourself that are maybe more about your anxiety of this. I can feel like I'm being productive without actually having to study.
Yeah.
So.
My favorite are the people that have to go out and they start asking questions about the supplies for mind maps. Procrastination is a real thing, right? And so we all face it. There is a great paraliminal, if you've got the paraliminal pack, called Get Around to It. And I use it all the time. I had to use it actually this weekend when I started to go down the rabbit hole, and I realized I was breaking things, and I went back and dealt with that. June, let me call you in here because this really goes to your wheelhouse. We do get some procrastination at this point, don't we?
Yeah, and it's, as you said, it's common. We all do it. All humans do it. We put it off to the last minute, and then we do it, and then we're like, wow, that wasn't so bad. Why did I wait?
Yeah.
And the problem with procrastination is we build up a lot of shame and guilt in ourselves that we didn't need. We didn't need to add that to our already heavy load by doing something. And that's why I tell everybody, if you can do it within 1 hour, knock it out, do it, and check it off your list. If it's not something that you can even do at all, let it go totally.
There you go. The fairy godmother reminds me of this on a regular basis. I fight it too. Thank you.
Jackson, let's move on to the biggest challenges that people are facing in this last little push before the exam. Certainly, there are some commonalities. So I will, if you don't hear yours specifically, I am grouping things together or paraphrasing, and hopefully we'll have time to get to them all. But if we don't, that's okay too. Just know that we did read all of them and are thinking about and praying for each of you with these things, and hoping jump on a group coaching call between now and the exam to discuss, because you're probably not the only one who's feeling that way.
Or post in the community group. And
yes. Yeah. Post in the community group for sure. Okay. The first one is really practical. And I like this as someone who's a planner herself. This person said, knowing what to do the day before the exam and during the breaks between the morning and afternoon sessions. I love that's like oh gosh. Well, I think the key is you need to find the thing that makes you feel comfortable and relaxed. Okay. So it's not a one size fits all, because for some people, something that's relaxing to you might be horrible to someone else and stress them out to no end. But what I think you do want to do is have it as a goal to be done with your studying by Sunday. I really suggest that by Monday, you are in a good, relaxed state. You may need to travel to get to your exam site. So you want to be doing that without panicking that I should be using this time to review con law. But you also, even if you don't have to travel, you want to just be refreshed and ready for the next day. So whatever that looks like for you, if you want to read a book, if you want to go to the beach, if you want to exercise, whatever it is, I would suggest something that do something that's good for your body, like eating healthy foods, go out, take a walk outside, or if it's very cold outside, like many of you guys, like do some sort of indoor, like just movement a little bit, right? Don't stress yourself out, just move a little bit. And then for the breaks in between, eat. Okay. Like I'm not saying don't like overeat, but you need fuel and energy. Your brain is working so hard. Please eat breakfast on the exam days. Please eat a good lunch in between. Okay. Don't stress yourself out and feel like I have to use every spare moment in between to study. Just take a relaxing, calm time. Be separate if possible from the other examinees. So if you are taking it at a big convention center, find a quiet little spot. Maybe you go back and sit in your car and have some food and read a book or listen to music that you enjoy, something like that, that's going to calm you, and don't be around other people who are panicking about the test or who are going to stress you out because they're going to be talking about things in the test and they don't know any more than you do, but it's very easy to feel, oh my gosh, like they know everything and I missed all this stuff. So yeah, just that's.
Yeah. And again, I would say if you've got the paraliminals, and if you don't, you should get them. The night before, you should use sleep deeply, wake refreshed. During those breaks during the day, either the 10-minute supercharger or focus are both great ones at lunch to be using. They're just wonderful. You just put them in, you pop in your earbuds and listen for 10 minutes up to maybe 20 or 25 minutes. And they are really very relaxing, very refreshing. But I would agree with everything that Megan has said in terms of what you want to be doing. I think quieting your brain the day before is really the key here. There's so much going on in your head, and we've talked about this, and it's quieting the crowd noise that's in there and just calming it down, bringing it down, relaxing, and getting yourself in that headspace where you're ready to go in and take the exam. I think that's a great way to do it. And I see Jim just put up the link to the paraliminal pack. You can order that and have it instantly.
All right. The next student said, I'm self-employed and this is the busiest time of year for me. Of course, gosh, not all this. They said, the good thing is that I started my studies early, so I don't feel as pressured as before. So good planning there. Good job. However, I was wondering if the best use of my time would be to focus now on my weak areas.
You don't need to do everything again. I mean, we're 6 days out and some people are saying, I need to cover everything. No, you don't. What you need to do is identify, I think, the 3 hardest subjects for you in essays, or the 3 hardest MBE subjects. And then you want to drill down to the part of the subject you're having trouble with. So people will say, I don't understand evidence. That's not true. There's some part of evidence you don't understand. Go there, study that, and work on that. Or if it's an essay, write a couple of essays, write 2 or 3 essays in that subject so you desensitize yourself to it and feel more comfortable on exam day. And that focus study at the end is far better than the cramming. We talk about what the big boxes do. If you're in a big box bar review today, you are sitting through 6 hours of lecture, you are still hearing material for the very first time. And you've got a huge advantage against the person that's doing that, because now you're able to target and pinpoint what you need, and they're still trying to accumulate, broad swaths of information. So I think it's definitely to your advantage.
All right. The next student said their biggest difficulty right now is focusing on their studies and centering their mind. And I thought this was sweet. They said they feel like they're nesting, like when you're pregnant and you're going to go into labor. They're like deep cleaning their house, and they're catching up like, oh, I need to call that friend I haven't spoken to since November. And right, you creating all of these other, which like we're talking about, I think this is really similar to that task avoidance of I'm creating all these sort of other things that I suddenly they feel very urgent, like they need to happen right now. So any advice for how to center your mind and focus on what needs to get done in these last few days instead of focusing on all the sort of other stuff happening around you?
Yeah, I think it's easy to focus on the parade of horribles. I'd turn off the television. I would not be watching the news right now. I understand the Olympics even are controversial, so I just stay away from all of that. And I'd really try to get into this quieter moment. I take some time in prayer, some time in meditation, some time to just center yourself. And I don't know anything about nesting except that I've watched it happen. But I think that the idea here is you want to get yourself in a comfortable place so that you are ready for the exam. Now, for me, that might mean going and getting a massage, or maybe just taking the walk that Megan was talking about, or taking a bike ride or doing some swimming or whatever it might be that works for you. It is, as you said, one size fits all is not what we're talking about here. But I like the fact that this student has the self-awareness that they're doing it. I think that goes a long way. But the tools that we offer, I think, can help center you. And if you don't want to do any of those, if you're saying, oh my God, I don't want to buy or add anything new, I understand that. At the very end of your course, there are self-care videos that go 5 to 10 or 15 minutes long, in which I walk you through some of these guided meditations to help quiet yourself and center yourself and do those. By all means, check them out. Students really respond positively to those. And I think those are the kinds of things you want to do. But yeah, just be aware that that's what's happening.
Yeah. All right. The next one, actually, June, if you want to hop back on, we have a few that I think you would be a great help with. So quite a few people said their concern in this last week is things like undermining themselves, second guessing themselves, feeling like all the work that they've been doing for these past months is suddenly not good enough and they need to throw it all out and start from scratch now in the last couple of weeks and not panicking. So any advice for all those students?
Yeah, don't do that. That's the advice. So what's happening, we've talked about this a lot in group coaching, is this is the ego talking, the place of fear. And it's trying to give you one last little punch because the ego is a little bit narcissistic and wants the control. And what you do when that comes up in your head is you just think it. Thank you for protecting me in my life when I needed you, but you're not needed now. And send it away. And the more you do that, the quieter it becomes because the ego is like a kid in a sandbox. It takes all its toys and it leaves because it's mad. And then it doesn't pop up in our inner talk or speak so much. And the intuition starts to come up louder because right now the intuition is a whisper because the ego is talking too loud. So the more we quiet the ego, the louder the intuition comes in. And that's where everything starts to flow and you feel more confident. You have the knowledge. It is all within you. There's nothing else you need to pass. You have everything at this point. You've done the work. So do not self-doubt. I say it ad nauseum. Do not talk yourself out of this. You know what you know and you know it well. Now just be comfortable and calm and allow it to come out.
Wonderful. Thank you for sharing that. I love that. There's a kind of a concept that you hear a lot in meditation where you just note the thoughts, right? So when you're trying to focus on just meditating and calming yourself down, and when you start getting distracted or the thought comes through, instead of judging the thought, you just acknowledge that it exists and then you can let it go, right? Without beating yourself up. We're all, a lot of us lawyers and aspiring lawyers are rather hard on ourselves, I think, high achieving and hard on ourselves. And so we have a tendency to say, I can't believe I'm doing this, or I'm thinking this, or why am I not? And it's just accepting, yes, I had this impulse, or maybe I even did. I cleaned or I did X instead of studying today. And just acknowledging it instead of judging it and being critical of the things. Just acknowledge it and then let it pass. Yeah.
And it never 100% goes away. This is why we work on it daily. Even people who do this all the time, the negative does pop up. And that's where you just talk yourself off that ledge and remind yourself, this is not really what's happening. And again, acknowledge it, let it go, and then move on with your life when that happens. So again, it's something we practice every day.
Yeah. And June, you might want to stay on for this one as well. I don't know if you or Jackson want to answer it, but the next biggest difficulty, as a few people said, getting to sleep the night before the exam and on the evening after the first day. Any tips or tricks for that?
I'm like Jackson. I agree with the paraliminals. A meditation, you can find tons of meditations on YouTube. Some even meditation music is amazing to listen to. Just what you want to do is soothe yourself. calm yourself down and soothe yourself. One thing that I love to do is I have a Kindle that has a non-blue screen. So at night, every single night, I will start reading a book on it. It's a joke in group coaching. I've been reading the same book for 6 months because it drops me to sleep in about 4 seconds. But I'm trying to read the book, but it's a non-blue screen. You don't want anything with a blue screen, your laptop, your cell phone, anything like that, 2 hours prior to going to bed. Seriously, check out of all of that and just do something that's very calming and soothing at that point. Jackson?
Yeah, the other thing that I would say is if you've got something like Bar Maps that has the fast finish audios, play the fast finish audios at the lowest possible volume on your phone. Just plug it in, put it under your pillow, and just let it go. You won't audibly be able to hear it. It will put you to sleep because of my dulcet tones, but it's actually good. It's your non-conscious is getting that, and it's really letting your conscious brain go off and play by itself, and you're able to drop off to sleep. So it's another good opportunity.
Wonderful. Thank you, guys. All right, Jackson, we have 15 minutes left. So if we'd like to, I think we have time to do one last subject specific discussion and then do one practice MBE question for our students. So maybe let's end with this and let people shake out the nerves a little bit right before the exam. Let's see how they can do with an MBE question.
So as we've been doing these study questions that keep you awake, and we've been moving through all of the MBE subjects. And today we're going to take the 7th subject for us, which is constitutional law. And we want to look at a topic within con law that is causing a challenge for a lot of people, and it's equal protection analysis. Really a part of it. Now, equal protection is a fairly large subject, but I wanted to focus in on how you apply the standards of review analysis when you're doing a con law question. So as we've been doing, I'm going to show you a mind map first, and the mind map has already been placed in your course in the con law section of your course. And if you've got the master class for this, it's also been placed there as well. And then we'll break that down. So you can see our mind map here for equal protection. And one of the things you'll notice is we have a lot of arrows here. And the reason we have arrows is that we want to be able to identify how different levels of scrutiny down there in that lower right-hand corner, how those different levels of scrutiny are actually going to impact the different kinds of problems that we might face. And so you notice that we've got the standards of review on the right, but then on the left, we have suspect classifications and other classifications. And then we have fundamental and non-fundamental rights. And that's what we want to look at. So let me break that down in a little more detail for you and let you see what we've got here. We are, as I said, in the equal protection section. And when we apply equal protection analysis, remember that it only applies to states and to the federal government. It covers citizens, it covers alien citizens, and it covers most corporations. And the purpose of the equal protection rules is that similar situations should be treated in a similar manner. So that's all, I think, pretty straightforward. Now, I'm going to jump past something called the methods of improper governmental classification. I don't think we need to know a whole lot about it other than to say that in this particular view, we've got de jure laws and de facto laws. That's not really our focus today. So I'm jumping down to the bottom to the standards of review because that's really our primary focus. As you probably know, we have 3 standards of review, and the first of those is the rational basis. This is what the court uses, and in order to find a rational basis and find that a statute or a law does not violate equal protection, all that has to be proven is that there's a legitimate government goal behind the legislation. And if you do that, then the state will win. So that's pretty simple. Then we have the more challenging area for the bar exam of intermediate scrutiny. This is the middle ground. And typically when you've got a problem dealing with sex or legitimacy, then you're going to be in intermediate scrutiny. And when you've got intermediate scrutiny, the test that you're looking at is the government has to prove that this law furthered government interests. It has to prove that it's not over-inclusive, and there has to be an affirmative duty to set out the objectives that you want to meet. And finally, there has to be a close relationship between the classification that we're studying and the objective. And you'll see that in just a moment. But intermediate scrutiny is, I think, the most challenging of all of these areas. And then we have strict scrutiny. When it's applied, typically means that our plaintiff will win, but it's only applied when you're dealing in a case dealing with race or national origin, or if you have a fundamental interest or a compelling need. And that's going to become really important, because if you know when to apply the test, it's really pretty easy to figure out what the result will be. Now, when we talk about these suspect classifications, that was up in the upper left, there are only two that we need to know: race and alienage. Those are the only two suspect classifications. And I will tell you that strict scrutiny is what applies when you've got race or alienage problems. So if you're trying to get a focus, that's where your focus should be. Then we've got everything else that's not suspect. And there's a big list, but illegitimacy, gender, poverty, age, mental impairment, economic regulations, all of those are considered other classifications. And for the most part, they are all dealt with by intermediate scrutiny. Then we get to fundamental rights. And here's where we've got our one exception. Fundamental rights include travel and fair criminal process, something called family and privacy rights, and then voting. Now, when we think about these fundamental rights, they are going to be driven by intermediate scrutiny. That's the standard of review, with the exception that family and privacy rights stand separate from that, and those rights are dealt with strict scrutiny. So draw a circle around family and privacy rights. If you see a problem that covers that kind of right, then it's going to be measured through a strict scrutiny analysis. And finally, voting. I don't know what to tell you about voting. Clearly, that's an area in flux. I would not expect to see questions on voting rights today, so I'm not even going to talk about it. It's worth another discussion by itself, isn't it, Megan? So there we go. All right, let's jump then to the last grouping, which is non-fundamental rights. Remember, we had fundamental rights of travel and criminal process and family and privacy rights and so on. Then everything else, which would be called all other things, and welfare benefits, are non-fundamental rights, and those are governed by rational basis. So if the government can say this is a non-fundamental right, then they can apply rational basis, and most of the time they'll win. So that's our structure, and we've broken it down, but I wanted you to see what's in there. And when you look at the larger mind map, the arrows actually become pretty important, don't they, Megan?
Yeah, definitely. You just want to know automatically, if I see X, then this is the test I'm going to apply.
Yeah, and I think that's what makes standards of review in some ways hard, but in some ways really easy. I just have to figure out if I'm dealing with a fundamental or a non-fundamental, or I've got a suspect classification or another classification, and then go from there. So I want to give you a practice question. We've got a couple, and they'll be loaded into your course. We have more questions than what we're going to cover today, but let's take a question. And I love this one. Megan knows I'm going to do this one. This is my heart, my love. City of New Orleans, pursuant to a state enabling act, has prohibited all pushcart vendors of food products from operating in the French Quarter. It's an important tourist area, unless they've operated in that area for at least 8 years prior to the enactment of the ordinance. Connie Croissant, a pushcart vendor who was selling pastries for only 2 years prior to the adoption of the ordinance, was denied a license to operate a pushcart in the French Quarter, while Bonnie Brioche, where do they get these names, has been vending pastries for 20 years, was granted a license. So we've got two different rules. Connie has brought suit in federal court attacking the validity of the grandfather clause. And so then the call of the question here becomes, what would be the best theory for the city to justify the ordinance? So this is one of those questions in which you're not going to have a binary choice. You have to think about the theory. And in order to figure that out, you're going to have to figure out what kinds of rights are in play here. And then you'll apply the standard of review. Is that a good way, Megan, to frame it up for us?
Yeah, that's exactly how I would do it.
Okay, so let's look at then our answer choices. So what would be the best theory for the city to justify the ordinance? Answer choice A says it's essential to limit the number of vendors to preserve the economic vitality of the French Quarter. So the key word there, I think, is economic, isn't it?
Yeah.
All right. Answer choice B, it's in the nature of a zoning ordinance and therefore reasonable. That's interesting. We didn't talk about zoning, so we'll see what you think about that. C says it is more likely that vendors with long experience will operate in a manner conducive to the charm of the area. All right. And then D, there is a compelling state need to improve the charm of the French Quarter. I resent that answer. Anyway, there's our 4 answering choices. All right, now, as you think about this, what you want to be doing, we're asked the best theory. So the first place is that you've got to ask yourself, what do we have here? Do we have a fundamental right that's in play? I don't know. Do we have a non-fundamental right? Do we have a suspect classification or another classification? I think we can certainly eliminate suspect classifications. There's nothing here about race or alienage, right?
Which tells you that we're not going to be dealing with strict scrutiny. So you can eliminate any answer that would be the right answer under a strict scrutiny test.
And do we have any fundamental rights here? Travel, fair criminal process, family, privacy rights, voting rights?
Nope.
Nope. So it looks to me like we're down to either non-fundamental rights or other classifications. Remember that in other classifications, we talked about illegitimacy, gender, poverty, age, mental impairment, and economic. And under non-fundamental rights, we had basically everything else. So I'd like you to take a moment now, and if you're with us live, make your answer choice here, A, B, C, or D, and then we'll look at them. Anything you want to add while people are making their choice?
No, I think what you would want to do, which I'm seeing some people do, is figure out which test this is going to be subject to.
Yeah.
And then you're going to figure out what's the standard, right? You're going to remember what the standard is for that test, and then figure out which theory directly addresses that test. That's the way that I would approach this question.
Exactly. And what makes the question hard is the way they frame up the answer choices.
Yes.
So I think when we break it down, you're going to see it starts to get a little easier, but it's a tough question. And so don't be afraid of it, but let's see what we've got here. All right, let's see. Hello. Okay, answer choice A says that it's essential to limit the number of vendors to preserve the economic vitality of the French Quarter. That's incorrect, because the real problem here was not economic vitality, it was discrimination between the vendors. Connie had worked for 2 years and Bonnie had worked for 20 years, and there was a difference in who got the license. So if we've got discrimination between the vendors in what they did, then that would subject the ordinance to scrutiny under the rational basis test. And so to say that the best theory for the city is that they're limiting the number to protect economic vitality really misses the subtlety of the distinction between the parties, right? There is some discrimination going on in terms of their opportunity to do their work. So A is an incorrect choice. You want to add anything to that, Megan?
Oh, just that this would be, doesn't address the problem of they're not saying the first 100 people to apply get a permit. Then we're not discriminating. They're saying, no, there's a difference. It doesn't matter when you come. We're saying these people get it and this other class of people or group of people doesn't. So this problem wouldn't address that discrimination between the vendors themselves.
Right, good point. All right, let's look at answer choice B. Would the best theory for the city be it's in the nature of a zoning ordinance and therefore reasonable? The question is really addressing economic regulations and discriminating between these vendors, not land use regulation. So nothing about zoning. In zoning ordinances, this question implies that they're all reasonable by definition, but that's not true. Sometimes zoning ordinances are not reasonable. So if you see a zoning answer, almost certainly it's not going to be the correct answer. So that's a good one to warn people off of. Okay, let's look at answer choice C. This is our correct answer. And I think it bears some explanation. Answer choice C said it's more likely that vendors with long experience would operate in a manner conducive to the charm of the area. This is actually built on a real case, which was New Orleans versus Dukes. But when we've got economic regulation, if you've got a state regulation like we had here that implicates the Equal Protection Clause, what's going to happen is it will be upheld as long as there's a rational purpose to the statute. Remember, economics were other classifications, and really all we had to do here was to get to rational purpose related to the statute. So in that case, the state said that, or the court said that a statute that regulated vendors in the French Quarter and prohibited people who've been in business for less than 8 years was reasonable based on the state's legitimate interest in preserving the charm of the French Quarter. So again, you want to just be aware that in this situation, you really have the opportunity to say, look, is there a real purpose behind the statute? Is there a rational purpose? There did seem to be. Now, is that a great theory for the city? Not necessarily, but I think it's the best of the choices, right?
Yeah, exactly. And you have to, that's why it's so important to know which test you're using as you go into it. Because if this was discriminating, if this was saying only Latino or Hispanic vendors are allowed to get licenses and Black vendors are not, we'd be under strict scrutiny, and having a rationale behind it would not be enough, right, to get it past strict scrutiny. But because here it's an economic regulation, the test is much easier, right? The hurdle is much lower. And so all they really need is to have this rational purpose behind it, which they do. So therefore, that's what this answer gets at.
Yep, absolutely. All right. And then quickly to look at answer choice D, said there's a compelling state need to improve the charm of the French Quarter. But again, the ordinance is economic, and therefore you've only got to get past intermediate scrutiny at the very highest level. And this choice would put the burden on the state if the state ordinance was subject to strict scrutiny. So as Megan just said, that's not where you're going to go with a question like this. So that's how you would deal with the different standards of review. I will tell you that we've got a couple of other practice questions that are already loaded up in your course so that you can find those and work through them. And I think you'll find that helpful. But we wanted to give you at least that taste of the exam at this point. So I hope that helps people.
Yes.
All right.
All right. So that's all we've got for today. I'm so glad we got a chance to talk about what's going on and last minute questions, and then deal with people's stress and anxieties leading up to next week. So hopefully that was helpful for everyone. If you have any questions or concerns as things come up over this next week, please don't hesitate to reach out to any of us. We are here for you. We are just so excited for you to knock this out of the park and to be done with it. And we're just thinking of you and praying for you, and hope that whatever the result is, that next week just gives you a great sense of peace and calm and pride in the hard work that you have put into this process.
Yeah, and I want to thank you, Megan and June, and all of our group coaches and our staff, everybody that works to make sure that this course works for our students. We are very proud of our staff, but we're really proud of our students. We're proud of those of you that have persevered and gotten to this point in your journey. Now it's just a question of showing what you're capable of doing. Let the examiners worry about the results. You just do your job, go forward, be confident, be all of the things that you want to be, dress like a lawyer to the exam, do all the things that help make you feel like you're ready to succeed, take that warrior stance and really go get it. But it's been a lot of fun, and it's been a terrific experience for us to guide you through this exam. We will catch you on the back end of the exam in a couple of weeks. We'll talk about what we heard around the country and update everybody there. And again, we will be on the community network on a daily basis, every day, all of us, to answer any questions or last minute concerns or problems. So don't hesitate to reach out there to us. And again, thanks everybody. Good luck. Have a great exam. We are very proud of you, each and every one of you. And we'll see you in a couple of weeks when you will be done with the exam, and our July students will be just gearing up and ready to go. It's so exciting. So thanks everybody. Bye-bye for now. All right.
Bye. Good luck.
Thanks for listening and watching the Extra Mile podcast for bar exam takers at celebrationbarreview.com.